Pessoal, boa tarde a todos e todas. Meu nome é João Marcos Guimarães Siqueira, sou diretor do IBDD e tenho hoje a honra de mediar esse painel com tantas pessoas de relevo, profissionais a quem eu dedico aqui toda a minha admiração, não só no Brasil, como internacionalmente. Explicar para vocês um pouquinho do contexto do IBDD Sem Fronteiras, que é um projeto pioneiro do IBDD, em que nós colocamos o membro filiado em contato com a comunidade internacional e com essa mesma comunidade a ideia é que nós troquemos experiências sobre cada realidade, sobre cada país, de modo que hoje selecionamos aqui o tema, o contrato do trabalho em diferentes países, não só no Brasil, como também no Reino Unido, na Inglaterra, né, e também na Espanha. Como a gente costuma fazer, isso já não é uma novidade no IBDD Sem Fronteiras, nós dividimos a conversa em blocos diferentes e a ideia é tratar em cada bloco específico um determinado tema. Então, só fazendo uma breve síntese para os nossos espectadores, para a nossa audiência, a ideia é, no primeiro bloco, tratar as questões principais do contrato de trabalho em cada país, falar um pouquinho sobre requisitos do contrato, como o contrato ele é elaborado, quais são os principais pontos na legislação nacional de cada país. O segundo bloco, falar especificamente sobre a questão de direitos de imagens também, saber como é que funciona o regulamento da imagem em cada país. No terceiro bloco, falar um pouquinho sobre os contratos de formação dos menores, né, que são eu diria, os contratos que antecedem os contratos de profissional, que os jogadores normalmente assinam em situações como essa, e no último bloco ouvir também um pouquinho da experiência de cada um dos nossos convidados. Como a gente tem feito, o IBDD Sem Fronteiras ele segue numa língua que seja possível que todos nós aqui participantes do painel nos comuniquemos, de modo que a gente vai fazer vamos fazer o painel em inglês e ao final de cada bloco a ideia é dar ao público um breve sumário daquilo que foi discutido. Eu vou começar aqui, então, fazendo uma rápida apresentação dos nossos convidados e vou agora mudar um pouquinho para o inglês. So, guys, I was just making this quick presentation about all of you, and there are a few things that I would like to highlight with you. And the first one is to thank Leo Massimo, because Leo, he has been a great partner of me. He is the one that been with me in this kind of project. And since the beginning, when we thought about making this panel about labor contracts in different nationalities, we didn't think there's no specific date that would let us to put all of you together. It's not a panel based on women. And we thought about bringing to IBDD the most relevant professionals that we have in the market. And just for a coincidence, all of you, we didn't focus on men, on women, and it was just trying to select the best that we have. And I'm very glad that at the end of it, we reached you and we have this panel composed by three great professionals I would say, worldwide. And I'm very glad to manage this panel. And I will make just a quick presentation about all of you guys, and starting with Carol. And I'll make just real quick in Portuguese. Carol Cos, ela é advogada britânica, Head of Sports Media and de entretenimento também do escritório Mills & Reeve, especialista em questões regulatórias no âmbito do desporto, como transferências e contratos de atletas, secretária-geral da IAF e mediadora da FIFA. So, Carol, thanks for accepting our invitation, and I know that you were rushing today, but you kindly accepted. So I'm just going to give to you for your initial greetings or your initial words. So thanks for coming.
It's an absolute pleasure to be here, and the beauty of Zoom, being able to be on this international conference with my friends and colleagues. And yeah, it's an absolute privilege to be here. So thank you so much for the invite.
All right, thank you very much. And moving to Rosalia. Rosalia, I would say that Rosalia is a closer friend to all of us Brazilians. She's She's been in Brazil for several times. I also had the opportunity to be a student of Rosalia here in one of the courses that I joined in Brazil. Rosalia é advogada espanhola, como todos nós sabemos, mestre em Direito Desportivo pela Universidade de Lleida, sócia-diretora da Sports Law Services, juíza de apelação da Federação Internacional de Pelota Vasca e presidente do Comitê de Disciplina da Real Federação Espanhola de Tiro. So, Rosalia, I assume that you understood everything that I said, but it's just a quick presentation, and I'm also glad to have you with us in the panel. Thanks for accepting our invitation.
Muito obrigada, muito boa tarde. Eu tenho que fazer umas palavrinhas aí, meu português com meu sotaque. Então, muito obrigada pelo convite. A você é um grandíssimo prazer também participar com o IBDD, como você estava falando, grandes amigos de muitos anos. Também enviar um saludo para Leo, que foi o cerebro de tudo isto também e ajudou. Agora sim, eu vou para inglês, tá bem? Thank you very much. I'm really, really glad to be here and to share with Fernanda and Carol and you. I mean, I think this is really interesting, and the most important thing is very useful, and more than anything right now that we are starting working in the summer market. So I'm here to help in anything I can do regarding Spain. Okay, thank you. I'm very happy to be here with all of you.
All right, thank you very much. And our final guest is also, I would say, more than a guest. It's a close friend that all of us we have here in Brazil, Fernanda Chamusca. Fernanda é advogada brasileira, mestre em Direito Internacional Desportivo pelo IGE, Law Business School, representante da CBF, da Federação Paulista de Futebol, no diploma de Futebol 2024-2025, pós-graduada em Direito Digital na Faculdade Baiana de Direito, membro e colunista do Instituto Brasileiro de Direito Esportivo. Nanda, in Portuguese to you, obrigado pela sua presença, obrigado por ter aceitado o nosso convite, and thanks for accepting, and I think it will be a great panel for all of us, and we have the opportunity to talk a little bit about the reality of each country and how it's the picture of a labor contract in Brazil and also in UK and also in Spain. Thanks for coming. Obrigado pelo comparecimento, Nanda.
Obrigada, João, pelo convite. Obrigada a todos. É sempre um prazer estar aqui, estar dentro de casa, para a gente falar de um tema tão importante. Introducing as the same model of Rosalia, just to say hi to everyone. But I'm delighted to be here, sharing the stage, let's say like that, with all of you, with João, that is a great friend, and with Carol and Rosalia, that more than friends, they were my professors in ISD, that Rosalia is at ISD now, the same place I started developing my career. So it's been a warm moment for me too, to remember those years and those moments that made me be here now talking with you like a panelist, let's say like that. So I'm very excited too, and I'm at your disposal for any doubts about the Brazilian system and to share a bit of our daily routine.
All right, so guys, as I said in the beginning, in this first panel, my intention is to go through general aspects about the labor contract of a football player in UK, Spain, and also in Brazil. And Carol, starting with you, I would like to hear from you your general thoughts about how it's, the main points of a labor contract of a football player in UK. And if you could just share with us your thoughts about contract and how it is the reality in UK. Now, I'm very thankful if you could just share with us a little bit.
Yeah, sure. So we don't have a specific law that's relevant to football or to sport, as you may have in other countries that I'm aware of. Footballers are, like, in principle, like any other employee, but clearly we've got levels of specificity of sport. So the way that it operates in England is that we have a standard playing contract, and we have a standard playing contract both for Premier League and EFL. So EFL is the English Football League, and it regulates all of the leagues below the Premier League, so Championship, League One, League Two. But it's the same principal terms for all of these players. And this contract is effectively our collective bargaining agreement. So the terms of the standard contract are agreed by the PFA, which is the Players' Union of Football Players, with the leagues. And so there don't tend to be too many changes in the standard contract over a period of time. And anything that is introduced that is new has to be agreed with the PFA. So another of the things that goes before is called the PFNCC. It's a chamber in which these sorts of employment type issues are negotiated. So anything that is relevant to players has to be kind of negotiated in that forum. So in 2020, the EFL tried to introduce a salary cap to Leagues 1 and 2. And because that hadn't been properly consulted with the PFA, there was a claim which we advised on, and they weren't able to introduce that cap. So basically, that's the way that we kind of deal with terms of employment broadly over the terms of the employment contract. Do you want me to go on and talk about some of the standard terms?
No, yeah, it's all right. But I'll make a few questions to you, just exploring your knowledge. And you said that we have a base standard contract, but can you customize the contract, for example, in terms of additional payments? Let's assume that you want to put in a contract that if the player scores more than 10 goals in a season, he will receive an additional payment. And how does it work for those specific clauses that you want to, sign with the player? Is that allowed? Can you do this in the UK?
Yeah. So the terms of the contract that are agreed, and we tend to refer to them as personal terms. So you sometimes hear the press say they haven't been able to agree personal terms, and that basically means the finances. It means normally the finances and any other benefits. It is called Schedule 2 to the contract. So this is additional clauses that are agreed that are additional to the standard terms. So that will be your standard salary, your bonuses, any extra provisions like a buyout clause or any additional benefits. We often have set salary perhaps for being in the Champions League, but then on relegation there will be a different salary, or on a number of appearances the salary will trigger, or on a number of appearances this will trigger the renegotiation of the contract, etc., etc. So yeah, that's where all the negotiation goes. It's called Schedule 2.
Perfect. I appreciate your explanation, and I'll just move on, leave a little bit England and go to Madrid, to Spain, just to speak a little bit with Rosalia. And Rosalia, it was, at least for me, very interesting to listen to what Carol said, because it's quite different than it is in Brazil. In Brazil, Fernanda will have the opportunity to speak just a little bit more. But we have a specific law for football players. But as far as I understood, in England, such a thing doesn't apply in UK. So heading to you, could you tell us the main aspects in Spain, how it is in Spain, and what it is in terms about what Carol said? If we could compare both realities, what's your view about Spain and how it is in your country?
Mm-hmm. Okay, well, first of all, I have to say that in Spain we have like very, very special system. First, because also, I mean, when you are going to take a contract, okay, the first thing that is going to call your attention is that even though if you have like a foreigner player, most of the time, the jurisdiction is going to be laboral codes, okay? I have to say that in 20 years that I'm working in football, I just saw one contract, it was last year, that the jurisdiction was fixed in FIFA. But this is something really, really strange. And the reason is because in Spain, to take the laboral issues to an arbitration is absolutely forbidden by law. Then usually what we do is we have to take, because we are obligated to take the laboral disputes to the laboral courts. Then, of course, very important issue in contracts is what is going to be the applicable law. In Spain, we develop really a lot in sport. Of course, we have our sports law, but also in relation to the laboral and sports relationships, we have a really old royal decree, 1006, coming from the year 1985. And this is the one that is going to regulate the special relationships of the athletes, okay? After that, I'm putting this apart. Also, we have like collective treatments. We have in football, we have in basket, we have in handball, and we have in cycling. And also for women, we have another one for football and another one for basket. So like this, you can imagine how much we regulate, how many rules we have. And on top of that, when you don't have something that is regulated there, or even though it's not in the contract, of course, we can do like step by step. First is what we have in the contract. Second, what is in our collective treatment. The next one should be this royal decree for the year 1985. And on top of that, is if nothing is regulated in the contract, we should apply like the general law. I mean, we have a lot of things. And this is usually how we work. I think I already answered you to the first question that's about what is specific. I don't know if you want also me to talk about exactly the same that you asked to Carol regarding bonuses and these kind of things. Or do you have any other special question?
Yeah, I would like also if you could tell us a little bit in terms of buyout clauses. How does buyout clauses they are applied in Spain? And you can move on just a little bit more. Just feel free to give us a general idea about some details of the contract.
Mm-hmm. Okay, well, regarding bonus, I mean, we don't have like a general regulation about this. Just, these collective treatments, they talk a little bit, but just in order to specify that any kind of money that you are going to receive regarding bonuses, I mean, contract bonus, match bonus, goal bonus, whatever, the only thing that we have regarding rules is that all this money is going to be considered as a salary, okay? This is very special. Of course, every kind of contract is not like Carol is saying in UK that you have like your general standard contract. Here, you can see every kind of contract with every kind of changes, and many times we have to change many things. But of course, I didn't see any football contract regarding a player that you don't have absolutely describe all the bonuses. And of course, there are bonuses that are particular, individual for the player, and collective as well. Like if you keep in the first division, if you are relegated to the second division. But there is not something specific rule, to be honest.
Perfect. And thank you very much, Rosalia. It was a great explanation. And then just moving to Brazil a little bit, moving to South America and reaching Fernanda. Nanda, as we could have the opportunity to listen Carol and also Rosalia. From my perspective, from my point of view, I can see that Spain is much closer to Brazil in terms of the picture, how the contract is. We're just a little bit more far away from UK, from England. And how about you, Nanda? Could you tell us just a little bit more about Brazil? What are the main aspects of contracts of the football players in Brazil? Just move ahead. Go on.
Of course, and it's very interesting to be the last one, because now I made some notes about what Carol and Rosalia already said. I think first and foremost, we must divide something that is very important to explain some differences. That is the common law and the civil law. That's why we are closer to Spain, and not because I studied in Spain and I know that it's kind of different and at the same time similar. In Brazil, it's very particular how we made it until, how can I say that? It's been not a mess, but it's been a mix of legislation at the labor stage and also at the sports stage. So some years ago, we had a big change over the labor legislation that applied the possibility to go to to use the arbitration for some issues related to labor disputes. So that's why we can enter and start saying and talking about the National Dispute Resolution Chamber of CBF, that is our Brazilian Football Confederation, that exactly the national federation that organizes our football. And at the same time, we can also talk about a new general sports law that has been published last year that came with a lot of differences and also reminding us about the different possibilities of employment relation. I'm going to apologize for you in the beginning to say that I'm going to bring a lot from football more than other sports because it's my reality now. So this general legislation brought all the characteristics of employment relation between the player and clubs. But what's the most important to say? We do not have a standard contract that will be exactly like England, but we have standard clauses that must be a part of the contract. So we're talking about compensatory clauses. We're talking about the length of the contract. So here in Brazil, the length of the contract must be the minimum of 3 months, the maximum of 5 years. And it's important to say under 18, same rule of FIFA. It's a new change from last year, the new legislation. So we must pay attention to that in order to elaborate the contract, in order to fix it between players and clubs and understand the differences between their divisions, between their salary cap and everything. And here we must have the compensation clauses that must be understood by the liquidated damage clause or buyout clause. I'm not going to enter into this discussion because we need another panel for that. And it is important to also establish the duties between players and clubs. We have it in the law, establish minimum criteria for that. But if we talk about the reality of football, for example, match fixing, that is something new. We can also establish other clauses that we call extra clauses that the player and the club must agree based on pacta sunt servanda. That is the autonomy of them to fix some terms on the contract, some terms that will be reasonable for a termination with just cause by the parties and everything related to that. So also in the legislation, it's important to say that we also have bonuses established. But in our case, those bonuses are civil matters, not salary. And it was a big change because some bonuses related to performance results in the past, they were considered salary. And only image rights by our previous law that is not revoked. So just to explain, we have a new general law that is establishing our labor standards, but we also have the previous law for some articles and some disposals that is not included in the new law. So we're passing a very important moment here about our legislation, but let's say like with a good study, you can understand and you can follow your job. So over that, our bonuses, of course, we have performance results. We have sign-on fees that is very common here. And the compensation clause, some people put as a bonuses, but I do not consider a bonuses because it is a standard clause and it may be executed or not. It depends on the parties, depends on the termination, it depends on a lot of factors.
And Nanda, I'm going to make you one tricky question, as you mentioned that nowadays we have I would say a conflict because we have two general laws running in Brazil, as you said. And sometimes those articles, they are just a conflict to each other. So in terms of image rights that we have the opportunity to speak about, but I would like to know just real quick, what's your opinion based on this point, and nowadays we have in Brazil two different, two general laws running at the same time. And what's your view about this? As you said, just a little mess in Brazil as a lawyer.
Yeah. I do not like to use the word mess, because it is a part of the legal system, especially the civil law. But it's been very hard to work on this situation. But what I did, as we know as lawyers, the new law will prevail if we try to compare with the previous law related to the same matter. So considering that, we need to have, on the first place, the new law, that is the 14,597, that is, we call Lei Geral do Esporte, that I'm calling General Sports Legislation because I made my translation. And we have the so-called Lei Pelé, that is the 9,615. And it's so tricky to try to read in Portuguese and say it in English, because I took some notes, and forgive me, this is my first time as a panelist in English. So it is tricky, but it's important to study, to make the comparison between both legislations. And I did it myself to understand what is in the new legislation, what is not included. So I need to consider the previous law. And in order to instruct the clubs, in order to be prepared for the challenges here at the federation, we did it as a team. So with my boss, Gustavo Delbin, with Renatini, other lawyer from here, Mariana Chamelete from the law commission of the federation, we did such a job to understand and make like a comparison between both laws, to understand what we can do to interpretate which law may be applied in each case. So basically that. So it's not that difficult anymore, because we did a huge study over there.
Perfect, Nanda. Very great explanation. And I'm just going to take a quick break in Portuguese, just to summarize about things that we discussed here. Então, pessoal, nesse primeiro bloco, na verdade, a ideia era trazer um pouco da experiência de cada país e como é feito em cada país, as características principais do contrato de trabalho. Eu percebi aqui que, na verdade, a realidade britânica ela é um pouco diferente da realidade espanhola e da realidade brasileira. A realidade espanhola, pelo menos por aquilo que eu pude perceber, ela está muito mais próxima do Brasil, na medida em que você tem um regulamento específico, lei específica. A Rosalia, inclusive, ressaltou também um ponto em comum com o Brasil, que são as disputas laborais em situações como essa. Há uma justiça específica, como existe também no Brasil, a Justiça do Trabalho, para dirimir tais conflitos, né? E a Fernanda dando um pouco da realidade do Brasil, né? Eu até fiz o que eu chamei de tricky question para a Fernanda, por conta dessa, vamos dizer assim, da vigência concomitante no Brasil de duas leis tratando de questões similares ou questões idênticas. E a Nanda deu a opinião dela, enfim, sobre a avaliação, como ela aplicaria e como ela interpretaria essa concomitância de vigência de leis. So, guys, just moving on to the second panel, this is one important thing that I selected, which is image rights. So at this part of the panel, I will start with Rosalia. And Rosalia, I think we will also have the opportunity to see how it is in Brazil and also in UK. But I would like to hear from you, how is the general concept of image rights? Is this a labor law in Spain or a civil law, or this is something that is not provided by the law? So if you could tell us just a little bit about this point, I would appreciate it.
Yes, okay. In Spain as well, we have something really specific, okay? Image rights is like, it's not like, it's a fundamental right. It's granted in the Constitution, Article 18.2, okay? This is first. Second, we don't have any other kind of specific sports image rights related with the athletes or sport events, nothing at all, okay? we have like a general organic law that is going to regulate how is working image. In any case, going directly to the subject and what's going on with the image rights of the players. First, I think that it's important to consider that it's a big and huge difference when we have like collective athletes, I mean, like the collective sports, like football, basket, whatever, and what's going on in the individual athletes, okay, like boxing, tennis, whatever, okay? I think that the main point here today is the collective sports. What's going on here? Of course, if you are going to be part or you are going to participate in a show, in a team, is yes or yes, you have to pass and give your image rights, because otherwise, you know, if there is no TV rights, there is no show, and if there is no show, there is no money, okay? So what's going on regarding the collective rights? Here in Spain, as I was mentioned regarding the bonus, all the money that you are going to receive regarding image rights is going to be considered salaries as well, okay? What was going on here in Spain some years ago? Okay, when you are going to pay taxes, okay, people realize, okay, look, maybe what can I do? Because, you know, even though I belong to a group, I also have my own image rights. I mean, I'm going to have my own sponsors. Of course, we are talking about top players, okay? So what usually people used to do, and nowadays just some of them are still doing, okay, I'm going to create my own company that is going to belong to me. And with this company, I'm going to deal with all the sponsors. What is the big difference and the main reason? Like in the most of the things in our business is the money. Why? Because if I'm going to pay taxes regarding salaries, you know, sometimes, and when we are talking about top players, maybe you can pay around 48%, depending. As much as you earn, as much as your percentage is that you are going to pay, okay? So they thought, okay, maybe I can create a company, and all the image rights and all the sponsor and all the contracts, I can do it like more civil or mercantile or cooperative like nature. And in this way, I'm going to pay the taxes more or less in the half, okay? So people and players start to think, okay, what's up if, as I have to give all my image rights to the club, I pass it through this third company, and instead to pay the taxes like laboral, we paid like a society taxes, okay? Of course, if you think, wow, this is a business, I'm going to earn a lot of money. What happened? Of course, you know, the Spanish government realized, look, we are losing a lot of money. We cannot allow this. But they decide, of course, you know, the players, the athletes, they can have these own companies, because at the end of the day, you have your own sponsors. So regarding the laboral contracts and your relationship with your club, nowadays in Spain is allowed to pass 15% of the money that you receive through a third company. I don't know if I explain myself clear enough.
Perfect. I have just one question.
Okay.
You said 15
Yes.
or 50?
15.
15, okay.
15, sí, sí.
Okay.
No,
Okay.
50. Okay. So this is like this. Another big issue regarding image rights is that, of course, you know, what I'm watching the last years, and even though, you know, like in first division clubs, I realized that at the beginning they didn't take care a lot about image rights. But nowadays, last year, I saw 2 contracts that really I was really impressed. You know, like 3 pages of image rights part inside of a laboral contract. And they start to say, okay, you know, you are giving us our collective rights, whatever. Of course, you know, you have your individual image rights. But in any case, we are going to put like special conditions. And, you know, in very, very important team in Spain, it's written there, okay, even though you have your individual right, if I bring you on a sponsor, and you are going to accept, you have to pay me 50% of what you are earning, okay? Which for me, okay, you are bringing me a business. This is nothing to do with laboral, okay? This is really apart. And this is very specific because really, as I think that there are many lawyers that are watching this and that, you know, when you have to take a contract, it's something really important. Okay, next step, they are writing. Okay, in any case, if you don't want to accept my sponsor, you cannot accept any other one. What happened here? This is a fundamental right, but the economic part of the image rights, you can say no. I mean, if you really write and you give your consent that you are going to say no to your own image rights, really is going to be a legal clause. So you have to consider really, really a lot what's going on. Because you know what happened, that sometimes players, or maybe they don't think that they are going to achieve like a top level. But sometimes, you know, it happened that private or individual sponsor is coming, but you already gave this right to the club. I mean, this is not very common. For example, in Italy, you know, it happened nowhere. Just for example, in Napoli, that they have this specific rule that no individual player, they cannot have their own sponsor. Okay, and here in Spain it should be like this. But the main point is what you are going to consent in the contract. Okay, and this, because really I wanted to say and put on the table this because it's happening a lot nowadays.
Perfect. So thank you very much, Rosalie. It was quite clear to me, and I can see some points of identification with the law in Brazil. And I think Fernanda will have the opportunity to go through this point. But before Fernanda, Carol, to you, we're listening to Rosalia. So if you could just compare both systems, England, UK, and also with Spain, about what we heard from her, what would be your main topics that you would like to highlight comparing both systems?
Yeah, there are some differences and some similarities. So we don't have, obviously, a common law system. We don't have a recognition of image rights per se as part of any law. And in fact, there is some debate. I just had a conversation with HMRC, our tax authorities, this afternoon, and it was all around what are image rights. They said we don't recognise the concept of image rights, but basically image rights are a bundle of rights. So they're things like in essence, personality rights, but we don't recognise those under English law. So, you know, perhaps trademark, copyright, you know, hard law. We have a thing called passing off, which is a common law sort of provision in England, but effectively it's a personality right, isn't it? And so the standard contract in England gives the clubs some access to the image rights of the players, clearly, because they want to use their players to promote club services, to promote their primary sponsors, and to promote the league. So that is primarily what the standard contract does. There are some rights, there's some rights to appearances, and as long as these players aren't used more than other members of the team, then there is access to this pool of image rights. So image rights have developed quite a lot in England, and this is where I see the similarity with Spain. And it is driven by tax, ultimately. It is more cost effective, cost efficient to run payments through image rights companies. Obviously, the rates are 20-25%, whereas in England, the employment rates are 45-47% when you include social security. So there are some significant tax savings. HMRC has traditionally run the argument that anything that you derive, even if it's off-field, is because of what you're doing on-field. So it's linked to your employment revenue. And there's been some cases about that. Things have evolved over the last 20 years. And then there was a kind of an agreement that HMRC reached with Premier League clubs, where there was an acceptance that actually, as long as payments from a global value of the player's deal didn't exceed 20% of that player's global pot, then that may be permissible, and as long as it didn't exceed 15% of the club's commercial revenue, then they may be parameters that the clubs could operate in. They are kind of guides now, but there's a real shift in the last 20 years in terms of the acceptance of image rights. And actually now, rather than just granting more rights to use a player's image or to get the player to do personal appearances in a club capacity, what we're seeing now is something that Rosalia also talked about, which was the acquisition of all of the player's image rights, not just in his club capacity, i.e. in his, kit, but also wearing his jeans and t-shirt in a totally personal capacity. And so in return for a substantial amount of money, the clubs are now, some of the clubs, the more high-level clubs, are acquiring all of the players' image rights, and then they are agreeing to have a revenue share. So the club and player agree that they will go to market, and whatever deals come in will come into the club. They will go into this pot, and then often the money is shared 50-50. So things have really shifted, and it is more, particularly for the very high level players, where there clearly is a real commercial value in their image. We are seeing a lot more image rights agreements now than we've ever seen before.
Oh, nice, very interesting information. And moving to Fernanda right now, Nanda, when I mentioned it to Rosalia, did you said 15 or 50? Because I understood in the beginning 50, which is I would say the same reality as we have in Brazil. So could you explain to us and share with us your thoughts about how these image rights are being ruled in Brazil, and what are the main points that the law basically in general says about image rights? What are the limits? So if you could tell us a little bit more.
Of course. It is important to understand in the beginning that image rights are granted by the Brazilian Federal Constitution. It is a civil right, as a personality right, as Carol already said. But inside the football system, let's say inside the sports system, we have here in Brazil 3 types that I think that it's very important to make some comparisons here. One is the image right from the spectacle, from the match, from the football itself. The second one is the image right of the employment relation. So it's the exploitation of the image rights of a player from a club that needs to exploit for even general conferences, social media, or anything related to the club. And to understand the 3 types, the commercial rights inside the image rights, that you can include sponsors, you can include partnerships, you can include a lot of things. But what is important to get here, both image rights from the spectacle, from the employment relation, they have different treatments here in Brazil. So one, it is a percentage for the players related to a match, that it is distributed by the TV company that send to the ones that owns the rights in order to distribute to the clubs or anything. It goes right to the representatives of players, like to the organism that represents players. So this is something. Here we're going to talk about the image rights exploited inside an employment relation. So these image rights, we have an article 164 in our new general sports law, that will define that you can have an exploitation of image rights inside the employment relation. It can be between the player directly, or between the player. It can be between the player and the club, or the player's company and the club. The only thing we need to understand is that we cannot pretend it is a fraud, but we must tried the most to comply with all the situations that image rights can be exploited in order to prove that you have reason to pay image rights. Because you cannot presume fraud inside the civil law system, but we cannot also allow the players to have labor charges being frauded. So that's why we have 50-50. So the limit for the image right to be paid as image right is 50%, and other explanation about it. For us, it's a civil matter, so it's not considered salary. As I said before, it is not considered salary, it is a civil matter, so you have a civil contract uh, related to image rights, that is a personality right, that you must put every single possibility of exploitation of this player's image in order to make the club have enough content to exploit, and also to prove that he have a reason to pay image rights. So besides all of that, we have also a connection that how can I say, writes the difference of the image rights related to the match, related to the spectacle, to everything, to the game, let's say like that, and the image rights of the employment relation. That is the one that you can also terminate a contract between employment relation can be terminated by the reason of an image right contract that has been not paid by the club. So even considering a civil matter, when we enter in another concept of employment law, that is remuneration and salary. You can also have salary inside of remuneration and other types of remuneration that is not salary, that is a civil matter, that is included in the remuneration. So taking that concept, here the legislator in Brazil understood that if you have image right contract that is not being granted for the player with all of the clauses, with the payment and everything, the player can terminate the contract if he have at least 2 months of late payment. So considering all of that, it's very different from Spain, very different from England. But I would say that it also changed with the general law, especially the percentage. Before it was 40%, now 50%. And for me, it's better because the new law, like the general law, established that what is not fraud. Before, we were like trying to understand why in some cases a fraud was presumed and in other cases were not. So now we are trying our best to apply into the reality. But I'm gonna say that it's a very good point in our legislation. It's better 50%, but I'm not gonna go into the percentage how can I say, reason or arguments or anything like that, because it's another matter of the freedom of the parties to decide into what they want to agree for.
Perfect, Nanda. Perfect. Very good. And just summarize very quick in Portuguese, everything that we discussed in this panel. Então, nesse painel agora a gente tratou um pouco sobre direito de imagem, e eu de forma bem breve aqui, por conta do tempo, vou tentar sumarizar o que foi discutido, pelo menos começando pela Rosalia. Deu para perceber que, na verdade, na Espanha, o direito de imagem ele não tem um regramento específico, muito embora pela própria Constituição ele seja considerado um direito fundamental. A Rosalia traz algumas questões em relação à taxação, algumas cautelas que são necessárias, inclusive, em situações como essa. Falou também da limitação de 15% em relação ao pagamento do direito de imagem ao atleta profissional, ao passo em que a Carol trouxe para a gente um pouco da ideia de como os direitos de imagem são regulados no Reino Unido. Me parece que não há uma limitação, e tampouco uma lei específica que trate dessa questão. Mas dentro daquele escopo inicial colocado pela Carol, quer dizer, os contratos eles já possuem aquelas cláusulas padrão, inclusive, Isso pode ser negociado com o atleta livremente, enfim, observado ali o interesse de cada parte. A Fernanda traz um pouco a realidade brasileira, inclusive fazendo eu acho que dando até uma amplitude maior, explicando, distinguindo o que é direito de imagem, o que é direito de arena. E ao contrário, tanto da Espanha quanto do Reino Unido, o que parece é que no Brasil, isso parece não, de fato é o que acontece, né? Direito de imagem tratado como uma verba de natureza civil, ao passo em que no Reino Unido e também na própria Espanha, o direito de imagem é essencialmente considerado como salário, né? Esses foram basicamente os pontos principais que eu destaquei aqui. And guys, I'm going to try, just because we're almost running out of the time, join the third and the fourth panel. Now I just start with Fernanda, just to be honest with all of you and to listen a little bit from her. And now we want to talk, Fernanda, about, as we say, in a literal translation in Brazil, formation contracts, non-employment contracts for minors, and how does it work in Brazil, how it is in Brazil, and also joining the fourth panel, the fourth block that we're going to have. Could you tell us also, what is your point of view in terms of being a lawyer or also working for a big federation in Brazil? What are the main concerns that the lawyer should take into account in signing labor contracts? What are the main points? If you could share with us your thoughts, I would appreciate it.
Of course. Let's say I'm going to speak a bit about my favorite thing, that it's training contract and the training relation between players and clubs. It's important to say that we can talk about training contracts and federative right for a non-professional player. Here in Brazil, we have this difference because any club, professional or an amateur club related to its federation, state federation, and to the national federation, the club can register the federative rights of non-professional players, of amateur players, to play amateur competitions, sometimes professional competitions, with the limitation that each competition allows. So what is the main point here? In Brazil, we have a system that training contracts may only be registered for training clubs. And when you understand training clubs, I'm talking about certificated training clubs. We have a different procedure here. Training club certificate that is from CBF. It is a specific procedure that under the law, Article 99 of the new general sports legislation, you need to prove as a club that you comply with all requirements to be a training club already certified. And it is very hard. We have 1,200, I think, clubs in Brazil, and only 55 are certificated by CBF. So only 55 can register into the registration system the training contract. It doesn't mean you do not have the federative right of the player if you do not register a training contract. It just means that under Article 99 of the general legislation, you cannot own domestic training compensation for that player. And what it means, if you have a training contract registered into the system, you have the right to sign the first professional contract of that player if you follow the requirements. So we have two types here. We have the federative rights of amateur players that can be signed by every club allowed to that. And you have the federative right plus the training contract registered into the system. Because the second condition is just allowed to training clubs already certified by the National Federation, by CBF. It is a domestic procedure that we established in order to be closer to the training process, in order to be closer to what we can do to create a better environment for the grassroots. So that is how we do it in Brazil. So you can start a federative right from 12 years old, but only sign training contracts starting from 14 years old because it's respected. It is under the constitution and also the legislation for kids and teenagers, the specific one. And as you said before, my main concern that I think that is very important. First of all, the wording of the contract is something very important. As you can see, uh, I speak English, but I guarantee to you that I go better with the Portuguese because it's my mother tongue. And you have my example here, but you may have the example of many other executives, lawyers, and everybody that are drafting contracts of worldwide and may understand exactly the terms they are greeting for. Because appearance is not a good word. A register for a match, it's a bit confusing. So we need to put clear terms into the contract. If you are a player, if you do not speak the language of your new club, try to get some advice. If you are an intermediary, try to put yourself into the relation as in the correct side. And I really think that wording is my first concern. The past of the player is very important too for the clubs in order to understand what is the type of person you're hiring, because it means uh, it's not only disciplinary issues, but every single issue that may cause a damage to the club's reputation. You need to check this before you sign an employment contract. So, and the last one that is something related to my daily routine, the documents you may provide in order to register that labor contract. As I'm going to pass the word for Rosalia and for Carol, they're going to speak about another issues about like work visa and everything. You may have the rush to register a player, but you also need to have the rush to provide the documents because it is mandatory. It is important for the stability of the system. So that's my advice. I would like to thank you, João, Carol, and Rosalia for the opportunity to be here sharing this moment with all of you. And it's very important for me that you two were my professors at ISD, and now I'm here sharing this moment with you. So it will be in my heart forever. And thank you, IBDD. Thank you, everybody. Thank you, João. And I'm at your disposal for any other doubts.
Thanks, Nanda. Very good. And again, thank you for accepting. I know that you were rushing. Also, you had a busy week. And Carol, just to be honest with you, and also with the time that we scheduled for the meeting, I will leave this third and fourth block to you and to say just a little bit about formation contracts. And you can also say your final words to our public and thanking you again for joining our panel.
No problem. So with regard to the sort of training contracts, the non-professional contracts, we tend to refer to them as scholarship agreements in England, and this is where these are the contracts that the players enter into prior to entering into a professional contract. So they're still in full-time education. They often kind of live in the facilities where they're being trained, and then they have their football training as well. And so players can enter into that 1st of January the 16th of their under 16th year. We refer to that as the training contract, we in the UK. However, from FIFA's perspective, and it's the very technical test of, are the players earning more than their football related expenses? As scholars, they are, because they can earn, I don't know, £800 a month. So actually, scholarship is the trigger for payment of the training compensation internationally. So I guess that's one thing to bear in mind. And then we can offer professional contracts on the player's 17th birthday. So often what happens is the player enters into a scholarship agreement, but as part of that, there is also an offer of a professional contract once the scholarship is finished, once they are able to enter into enter into a professional contract. And I guess the related point on this is how our recruitment in England and the UK has changed. Because what we used to do very well, Rosalia is probably really happy about this. We used to go and poach players from Europe. So between 16 and 18, we had this exception that under the FIFA regulations under Article 19, and we could go and bring these players in. We could give them a scholarship agreement, so we could go and get the best Spanish 16-year-old, bring him in, give him a scholarship agreement, and we would then just pay training compensation to the Spanish clubs. Now we're not in the EU, so we don't benefit from this exception, and I'm sure Europe's really, really happy about that. So what we see now is that the recruitment strategy of the clubs are changing. So we don't have the benefit. We don't have the benefit of signing EU players easily. But what we do have now is a GBE system, a work permit system, which is point-based. And the points are based on, sometimes it's how, if the player plays for the national team of the country. So for the likes of Brazil, which is currently ranked second over a 2-year period, if the player is playing for the Brazilian national team more than 30% of their games over the last 2 years, the player will be automatically granted a work permit. But the system is also skewed so that there is a value attributed to certain leagues and certain competitions. And actually, the Brazilian, the Mexican, and the Argentinian leagues are all valued a lot higher than some of the leagues in, say, Scandinavia. So for an English club, for a UK club now, it works out that actually it's fertile recruitment ground to go to Latin America to find players. And so the points-based system also looks to Copa Libertadores, Copa Sudamérica, and they value these competitions in just the same way as we would value Champions League or Europa League. So yeah, there are increasingly more Latin American players, and not just national team players, but players that have been competing in the domestic league and are even just sometimes in the squad for these continental competitions. So we're seeing a lot more Brazilians, Argentinians, and Mexicans, and Colombians actually coming into the league, and I think that is a trend that is going to continue. And finally, I'd just like to say thank you so much for the invite. It's been an absolute pleasure. I feel like we needed way more time to talk through these things. It's just, there's so much to talk about, especially when you start comparing the different jurisdictions. It's fascinating. So yeah, it's been an absolute pleasure to speak to you all today. And yeah, I hope we get the chance to see each other in person again soon.
All right, thank you.
I do now need to leave. I am so sorry. But thank you.
All right, just feel free to leave. And also, again, thanks for your time. And I know that you're, as Rosalie and also as Fernanda, you're also rushing today. So it was a great pleasure to meet you. And I expect to meet you again easily in the future, because I didn't graduate as Fernanda did, but I expect to do it at the end of the year. So I'll be in Madrid in July and at the end of the year. So I wish we could meet together in the future, right? Thank you very much, Carol. And Rosalia, just for you, I will give you the final point so you can move on in this theme that we were discussing right now. And if you want to say your final considerations in Portuguese, it's up to you. Just go ahead. It will be a pleasure to listen from you.
Okay. Well, first of all, I think that we have to consider that, training contract is a contract that sometimes, the athletes or the coach, they are like in training periods, and this is the main goal of the training contract. So it's like to qualify as a professional. Here in Spain, also, I mean, we don't talk even about amateur, because it's like we are. I mean, it's absolutely the contrary. Why? Because it's also inside of our royal decree that is talking about a special relationship of the professional players. And what's up here? Even though you think all the requirements that you have to have, the first one is that, they cannot earn less money than the minimum salary. That, for example, in Spain is 1,100 whatever, okay? So usually when you are earning more than your expenses in your sports, you are a professional, okay? So you go inside of this rule, and you know, in the Article 4, they absolutely talk about the training contracts, okay? The main point here is, okay, what is a training contract? Okay, you can do it with people between 16 and 25. Why? Because 16 is the age, the minimum age to work. You know, you are really a worker even though you are in a training contract. Okay, what's up here? You can have it minimum 1 year, maximum 3 years, because this is the time that you can consider that you are going to train or as a professional, even though an athlete, okay? Actually, when you have this kind of contract, 75% of the first year, you can be working, but the rest, you have to be like, you know, like really training or doing any kind of other activities. And the rest, the second and the third year, you can work the 85%. What does it mean? That you are not going to be working all the time because in theory, you know, you are training. What's up here in Spain? The main point here in Spain regarding the training contracts is that the government understands that the club, that is a company, is helping to the people, to the young people. I mean, it's not like Fernanda was explaining very good. I mean, if you want to be like a training club, you have to have some kind of issues. Okay, here in Spain, we don't have this. The issue is specifically case by case regarding each person and the contract. And the main point here is, you know, for the clubs, when you are assigning this kind of contract, you are out of taxes regarding social security, even though the worker is going to have it. What's up here that, you know, during many years, and you know, the athletes, usually they are like young, clubs used to use this training contract. Yeah, why? Because, you know, they really wanted to save money, but actually, the reality is that they were not these training contracts. And, you know, really sometimes government, they are really, really focused on this. We have a great inspection regarding this because we really want to know if this is a training period and training contract with all the profits that you are going to have, or if you are really using in a fake way. You know what I mean? So in general, this is something that we have regulated for athletes, for professional athletes, with a minimum of elements. And with this, I think I could explain more or less with these training contracts here in Spain. Of course, it was a great pleasure. Vou terminar com umas palavrinhas aí em português que eu adoro. Então, muito obrigada. De verdade, foi uma grandíssima honra para mim ficar aqui com todos vocês. Eu sempre fico à vontade com vocês. E nada, fico à sua inteira disposição também. Muito boa tarde.
Boa tarde, e eu vou me permitir também, aproveitando que a Carol já saiu, fazer essa saudação final. Vou pular a tradução até para poder ser honesto com as meninas, que eu prometi que nós terminaríamos pontualmente às 15h10, com 10 minutos de acréscimo, que seria ali a tolerância máxima para o nosso painel. Mas em nome do IBDD, Rosalia, você que é quase que brasileira, né, Rosalia? Enfim, tamanho o seu
ADN brasileiro,
país,
sim,
né?
sim. Bailo samba também, né?
Sim, sim.
Claro.
Então, eu queria te agradecer muito, agradecer a Fernanda também, agradecer a Carol que saiu, agradecer também a presidente Raquel, que também prestigiou aqui o nosso painel, o Caio Medauá, Renato, Solange, o Felipe Souza, o Marcos Ribeiro. Foi um prazer estar com vocês aqui nesse IBDD Sem Fronteiras, trocar um pouco de experiência para poder saber a realidade de cada país e como funcionam as questões contratuais inerentes ao jogador profissional de futebol. Muito obrigado a todos, obrigado Rosalie e Fernanda, e devemos ter, eu acho que daqui a 3 meses, a 5ª edição do IBDD Sem Fronteiras, mas até lá a gente vai ter tempo suficiente para poder montar um outro painel para trazer aqui para o membro filiado do IBDD. Então, muito obrigado a todos, boa tarde, Rosalia, Fernanda, muito obrigado, gente. Até logo, boa tarde.
Obrigada, boa tarde.
Tchau.
Tchau.